Right then, David, why would I use a forensic accountant?
I think it's useful for solicitors sometimes to bring in the extra expertise that a forensic accountant can offer. We are numbersmiths rather than wordsmiths, and we have software and skills and experience of preparing accounts for legitimate businesses and illegitimate businesses, and we can bring all of that expertise and skill together to help you to help your client.
And why would I specifically use Bartfield's forensic accountants?
We have a tremendous amount of experience of criminal and civil cases. I personally specialise on the criminal side, and I'm well known for my work on confiscation cases. Other directors specialise in civil, personal injury, matrimonial, all sorts of cases like that. So we can bring the full width of expertise together, and we have a team of support staff so that we can put, if need be, a lot of time and effort in a short period of days into a case where there's perhaps a particular deadline to meet or something like that. One of the other things to be aware of course, is that if the solicitor does the work himself or herself, then he's not able to go into the witness box and give evidence if that's required. Of course, as independent experts, we are able to go into the witness box, and we're used to doing that and dealing with examination in chief and, of course, cross-examination in civil and criminal cases.
Do you do criminal work?
Yes, we do a lot of criminal work. In fact, all of the work that I do is criminal work because that's my particular interest and my area of expertise. But we also have directors who do civil work.
And what about legal aid work?
Oh, yes. Yes, most of the criminal work we do is under legal aid.
And prison visits?
Yes, we do those as well. It's quite useful sometimes to meet with the defendant, and of course if he's in prison, that's where you have to go.
Would you come to my office to see my client? Because that obviously is where my client is going to feel most at home, and I'd like to be there in the interview.
Yes, we would like you in the interview because that means that legal professional privilege applies to anything that's said to us. It is useful sometimes to meet with the defendant in person, discuss the whole fact and background to the case and the financial aspects as well.
How much does it cost?
It depends. It depends on the complexity of the work and the number of hours involved, but typically a few £1,000s.
Right, David, can you just give me an overview of what you might do in a confiscation case?
Yeah. A lot of the confiscations we do are criminal lifestyle cases. So you've got a benefit figure which is made up of the benefit of the particular criminal conduct and assumed benefit of various types. So we would look at the detail of that benefit, look at what's in the Section 16 statement and the appendices. The Section 16 statements that you get vary very much in quality, from very competent and well-prepared statements to statements which quite literally do not add up. So we check all of the statements, all of the detail, then we gather information to test, for example, whether some of the credits that have been assumed benefit are in fact simply monies from another account, to test whether a benefit is assumed on, let's say, an account in the name of a limited company where the defendant is an individual, or an account in the name of the defendant's wife or girlfriend or husband, and not the defendant himself. And there are issues that arise in those connections with piercing the corporate veil and with the burden of proof on the prosecution to show that, for example, a credit to a spouse's account has actually been of money obtained by the defendant himself or herself.
As a solicitor, would I be able to basically ring you up and ask you a question?
Yes, anytime. Sometimes the best way to ring us up is by email, but we do respond to questions without any charge or obligation from solicitors. And indeed, if a solicitor's got a Section 16 statement, we're happy to look at that on a no charge and no obligation basis and come back and say whether there are particular points which we think are important and whether we might be able to assist.
So, David, I don't want my client to think that I have gaps in my knowledge about his or her particular case. How do I justify then calling in you as an expert?
I think what the message that we would be giving your client is that you have gone the extra mile by looking for particular expertise to help him when he's facing a trial or a confiscation, to give him the fullest package of support you can. And of course, it doesn't cost the client if it's under legal aid.
That is probably what the solicitor will be most concerned about, the cost.
Yes, I understand solicitors are concerned about cost, but it is covered by legal aid, and so that ultimately the client isn't going to have to put his hand in his pocket. And of course, in confiscation cases, very often the client's assets will be under restraint, so he couldn't possibly pay anyway.
Most confiscations are settled by agreement, possibly at the door of the court or earlier. Does that mean that you weren't needed after all?
Well, no, I don't think it does. Indeed, I think instructing us helps you reach a sensible agreement with the prosecution, because they can see that their figures have been subject to a critical review and challenge, and they are then sometimes prepared to reduce their figures of benefit, for example, quite substantially in the light of what we've been able to say to them.
Would the prosecution bring an expert to court?
It's very rare in practice for the prosecution to bring an independent expert. What happens with the prosecution is that they usually bring the author of the Section 16 statement, who is a financial investigator, but in most cases not a properly qualified accountant. And because of that, they are facing somebody from the defence side who has more skills and more qualifications, which puts the defence at a relative advantage.
How should I specifically instruct you?
If it's a trial, the easiest thing to do is to give us access to the criminal justice system digital file. We can then download all the prosecution papers and examine them quite easily. If it's confiscation, then what we'd initially like to see is the body of the Section 16 statement. Not all the appendices at that stage, because they can be quite voluminous. But if we see the body of the Section 16 statement, we can look for the technical issues and look for the key points that interest us. And under legal aid, we can do a fee estimate, and you can then apply for a prior authority.
Do you do work for the prosecution?
Yes, we do. We're instructed by police forces, by the Crown Prosecution Service on prosecution cases. Of course, we can't be acting for both the prosecution and the defence in the same case.
Can you give me some examples of important cases that you've been instructed on?
Yes, I've been instructed on a couple of cases in the past couple of years which have gone on to appeal and have established some quite important principles. One was a case involving a Mr. Harvey, which concerned VAT charged by his business, which was included within benefit, and the Supreme Court eventually concluded that it was disproportionate for him to have that included in benefit when he had already accounted for it to HM Revenue and Customs on his VAT returns. And another one was a case involving a company called Boyle Transport, where the issue was piercing the corporate veil and whether the directors and major shareholders in that company should be regarded as having received or obtained benefit from the takings of that company banked into the company bank account.
So solicitors can rest assured when they instruct Bartfields that they're getting a team of forensic accountants who have seen it all.
Well, yes.